Good afternoon. My name is Melanie Blackwell, and I'm a policy analyst with the Office of the Public Guardian and Trustee. I'm pleased to welcome you to the following session of the Office of the Public Guardian and Trustee Learning Series for 2016. This webcast is part of the Human Services Learning Series, a joint initiative from the Government of Alberta's Human Services Department. Today's session is focused on providing information about the Office of the Public Guardian and Trustee functions. And I'm pleased to welcome my colleague Lincoln Marr from the Office of the Public Guardian and Trustee to present this information with myself. Lincoln started working for the Office of the Public Guardian and Trustee in 1990, specializing in trusteeship services. He currently functions as a review officer and a trusteeship specialist for the office. We will have an opportunity to answer questions at the end of the session, so please write down your questions and we'll go through them at the end. Once again, thank you for attending and welcome, Lincoln.
Thank you, Melanie, and welcome everyone. So I am here today to tell you about the official guardian functions that the Office of the Public Guardian performs. Generally, the Office of the Public Guardian and Trustee deals with three groups of clients. There are represented adults, essentially adults who are not able to make their own decisions, either personally or financially. Those are situations where the public guardian and trustee might become guardian and trustee for those individuals. And of course, we have a large role in processing and dealing with private applications for guardianship and trusteeship. Then there is the role that the Office of the Public Guardian and Trustee plays in regards to deceased estates. So individuals who pass away in Alberta where the situation warrants the involvement of the public trustee in some fashion, perhaps on behalf of a beneficiary, or perhaps because there is no next of kin in Alberta or no one who's able to deal with that deceased estate, so the public trustee might have to step in and actually administer that estate. And of course, our subject today, official guardian estates. So essentially, official guardian estate administration deals with generally kind of two areas. Approximately 95% is dealing with minors in Alberta, that's persons under the age of 18, and their estates and funds payable to them and so forth. And about 5%, maybe even less, of the official guardian function deals with missing persons, either, for example, a beneficiary under a deceased person's estate that cannot be located, or potentially if an oil company wants to drill a well or do some exploring on a section of land, or drill a well and they can't locate all the owners, the registered owners of that property, then there are processes that allow the public trustee to kind of step in for those missing owners and collect whatever royalties or fees or anything of that nature, and hold it in trust for those kind of missing individuals pursuant to those regulations. But today I'm going to basically deal with the majority of what the official guardian functions are, is dealing with minors' funds. As I said, a minor is anyone under the age of 18 in Alberta at this time, and there's actually a piece of legislation that sets out the age of majority in Alberta. Very short, but it does exist. And one of the first things I did learn when I came to the Public Trustee's Office back in 1990 is that a parent is not automatically the trustee of their minor children's estates. They are the guardian of the person of the minor, so again, making personal decisions like medical decisions and things of that nature, but they're not the trustee of the estate of their minor children without a specific court order under the Minors Property Act. Now, normally this makes no difference at all to any minor because most minors don't have an estate. But in those situations where a estate does arise, as I'll deal with later, that's when the public trustee does get involved. Usually the public trustee will deal with minors and estates and funds for minors in one of two ways, either through an inheritance where the minor is either a beneficiary under a will or under an intestacy when someone dies without a will, or potentially is a beneficiary of a life insurance policy or a pension plan or some other kind of asset where a beneficiary can be designated, or if the minor is the recipient of some kind of damage award, whether it might be a personal injury award themselves because they were injured in some kind of incident, or it might be a damage award because a parent was injured or killed at the fault of someone else. In general, when the public trustee does hold funds for a minor, we do pay interest on those funds, or the government does pay interest on those funds, and there is a fee for managing those funds that is kind of taken off, that is taken either annually or when the funds are paid out to the minor or paid out to the appropriate person. So in regard to inheritance, as I indicated, so generally that would mean when a minor is the beneficiary under a will or under an intestacy. That means when someone passes away without a will. It also could mean that the minor is the beneficiary of a life insurance policy. So again, this kind of standard situation where one spouse might make their other spouse the primary beneficiary of a life insurance policy, but if that other spouse passed away or had previously passed away and they hadn't changed the beneficiary, they might have, if that person is no longer alive, then I divide my insurance between all of my children. And if so happens that some of those children are still under the age of 18, when the initial insured person passes away, then our office might be involved. As well, there are, under the standard automobile insurance policy in Alberta, there are what's known as Section B automobile insurance death benefits that are payable to either the spouse or the minor children, minor dependent children of an insured individual, again under certain circumstances, so potentially those might be monies payable to a minor. Also, if an individual is killed in a workers' compensation situation, there might be workers' compensation board benefits or dependency benefits that are payable directly to the minor, again, depending on the situation. And again, like I said, in any other situation where a beneficiary can be named, RSPs or pensions or anything of that nature, then it's always possible to name an individual who might be under the age of 18 when the funds do become payable. How does the public trustee know about this? Obviously, we don't have listening devices everywhere. What happens is that under the Estate Administration Act, the legislation indicates that the public trustee is to be involved, is to be served with notice whenever a minor has an interest in an estate, whether that be just a very small interest. So it could be $1 million estate, but if the deceased person had left their chess set to their great-grandson, and the great-grandson happens to be 3 years of age, then the public trustee has to get notice. As well, if there are dependent children, so they would be direct children of the deceased, and again, depending on the situation, if those individuals weren't left the entire estate, then those dependent individuals, whether it be the dependent minor children or the dependent spouse, they actually have certain rights under the Wills and Succession Act to potentially make a claim for a greater part of the estate than they would get under the legislation. So there are those rights that exist as well. That would involve the involvement of the Public Trustee's Office. As well, as I said, insurance proceeds, most insurance companies are aware that part of their process in terms of paying a claim is identifying the beneficiaries and so on, and if they become aware that a beneficiary is under the age of 18, then they will normally contact us to see what, if any, involvement the Public Trustee's Office will have in the claims process. And that is true even if there is a trustee named in that beneficiary designation. So, for example, you could have a life insurance policy that you leave to your grandson, and the person is under 18 at that time, so you can, often there's a space, or you can write in, if the beneficiary is under 18 years of age, I appoint their mother, Sarah, to be the trustee of these insurance proceeds until the beneficiary turns 18 years of age. In that case, the public trustee would still be involved, but potentially not to actually hold the insurance proceeds, but maybe to monitor them, but maybe just to assist in completing the claims process. As I previously indicated, under the Wills and Succession Act, it indicates that if a minor child's share of the estate if a minor child of a deceased person doesn't get the full estate, then that minor child has a right. So it's not an automatic, but there are rights that the minor child or someone on the minor child's behalf has to make a claim against the estate for a greater part of the estate, and that claim can be made by the minor's parent, the minor's guardian, if those are different people potentially, or sometimes might be made by the public trustee's office on behalf of the minor. And again, it's just the right to make the application. The court would consider all the factors and determine if in fact that minor dependent child should receive a greater portion of the estate or not. If the public trustee is advised that there is a minor who has an interest of some type in an estate, then for example, if there is real property that forms part of that estate, then the public trustee has to consent to the transfer of that property, even if the minor doesn't have an interest in that property. So for example, if someone passed away and they left their house to their spouse, and they left $100 to their minor children, so in addition to all those other rights that I previously mentioned, even though the minor under that scenario doesn't have a direct interest in the house, the public trustee's office would still have to affix our consent onto the transfer of land that the executor would sign, transferring the house from the name of the deceased person into the name of the spouse. If the minor has an interest in this, in that real property, so for example, in that same scenario where the person passed away and they said, I leave all my estate to be divided equally between my spouse and my minor child, and part of the deceased person's estate included a house, then we would want appraisal information to make sure that, if the house is sold or transferred or what happens, that the transaction is being done at kind of a fair market value to make sure that the minor receives the share of the estate that they're entitled to. If there are funds payable to a minor, so again, under a will, if it says I give half of the estate to my minor child, to my children, and it just so happens at the time the person passes away that one or more of those children are under the age of 18, and if the will or trust instrument doesn't contain any other language about setting up a trust for minors or anything of that nature, then depending on the amount of funds that are payable to the minor, the funds may be paid to the public trustee's office to hold in trust for the minor, or pursuant to the Minors Property Act regulations, again, the main focus being how much money it is. The funds could also be paid to a parent or guardian who has the power and responsibility to make day-to-day decisions on behalf of the minor, or in specific circumstances could be payable to the minor themselves if the minor has the duty to support someone else, like has dependents. So, you have a 17-year-old individual who may already have dependents, could be married, could have children, it's possible. Then again, in those certain circumstances, the funds could actually be payable directly to the minor as opposed to either a trustee or to the public trustee's office. If there is a trustee name, so again, in a will, a bequest is made to an individual who happens to be under 18 years of age, and the will contains language that says either that specific gift or, if any beneficiary is under the age of 18, then I appoint so-and-so as the trustee of that gift to hold until the person turns 18 under these conditions. So if a trustee is named in the trust instrument, or if there's a court order that indicates that the gift is to be paid to a different individual, then the funds for the minor can be paid to that individual, and the public trustee will not monitor those funds unless the trust instrument tells us to. So unless the will itself said, and I want the public trustee to monitor the trustee's administration of the minor's funds, or if the court directs the public trustee to monitor that outside trustee's funds. Otherwise, once those funds are paid pursuant to the trust instrument, whether it be the will or a court order, then the public trustee will not monitor the administration of those funds anymore. Obviously, if an outside trustee is appointed, they should obviously be keeping proper records and administering those funds properly on behalf of the minor, and they would be bound by the provisions of the Trustee Act of Alberta and any other provisions either in the trust instrument, like the will, or potentially if there was a court order issued. If funds are paid to the public trustee's office on behalf of a minor, essentially how I've always described it is that for each individual person each individual minor that we hold funds for, we have a separate account number, a separate, so when we can always track, so if we receive $2,000 or $20,000 or $200,000 on behalf of a minor, it would go into that specific account that's set up for them, and we can track how the monthly interest being paid, any amounts being paid out, and so on. In practicality, kind of like a giant mutual fund, what happens is that all of the funds that we hold on behalf of all of those minor clients, and in fact some of our represented adult clients, they all go into one big fund, what we call our common fund, and that's because in that way we can generate more interest and get better terms, and essentially it's a better investment if we can invest the funds as one big lump sum as opposed to $2,000 for this person, $6,000 for this person, etc. But again, like I said, we can account for every penny for each individual account. So to the outside person, to the minor beneficiary or to his or her parents, I always say just consider it like we hold a bank account for that individual, and we can account just like you could, the bank could account specifically for that bank account. How the bank invests the money that you deposit in your savings account, you don't really care. You only care that they can account for the money you have in there. And just like that, that's how the public trustee kind of deals with the money that we hold. Again, there are a lot of kind of checks and balances in regards to how the monies are invested and so on. As well, if the monies that we receive are under $10,000 at the current time, that's the regulated amount under the Minors Property Act, then again, in the appropriate circumstances, the Public Trustee's Office can in fact pay the monies out to the guardian of the minor, who has the power and responsibility to make day-to-day decisions affecting the minor. Right? So again, in certain circumstances, even though the monies are paid to us, because the Public Trustee is kind of the default payor or payee, I guess, of monies, in certain circumstances, we can then turn around and pay the monies out to the guardian. If we are holding funds for a minor pursuant to the terms of a will, then we'll make funds available according to the terms of that will. If there is no trust document, such as a will, or if the trust document is silent as to how the funds are to be used, then the public trustee can use some or all of the funds held on behalf of the minor for the benefit of the minor, as long as it's in the best interest of that minor. Again, funds received under an estate, particularly if it's a parent, are available for day-to-day expenses, education expenses, maintenance expenses, essentially, any responsibility that had that deceased person still been alive, particularly if it's a parent, that individual would have been responsible for as well. Requests are reviewed on a case-by-case basis, right? So again, what we might approve for one individual, we might not approve for a different individual, again, depending on the circumstances of the family, how much money we're holding, and so on. If, in fact, we are paying funds out of a minor's trust, then we do try to advise the minor that their trust fund is being used when the minor turns 15 years of age, unless unusual or special circumstances exist. And again, that's all done on a kind of a case-by-case basis. We'll deal with the parents or guardians of the minor in those kind of cases to do what we feel is best and in the best interest of the minor. When the minor turns 18 years of age, generally that would be the age when the monies are to be distributed, though potentially under a will it could say pay it out when they're 21 or 25, and again, depending on the circumstances, the public trustee might actually hold the funds until the designated age, whether that be more than 18 or 25. But generally speaking, most often the monies that we receive are because a person passed away without a will, so there is no trust document, there are no directions. So in that case, the monies are payable to the individuals when they turn 18 years of age and are no longer minors. What we do is we provide an accounting to the minor at that time, unless we have information that there is an issue with the mental competence of the minor individual. But assuming the minor doesn't have any issues with their competence, we provide an accounting. If the trust beneficiary is satisfied with the accounting, they provide a release to our office, and then we pay out the funds to them. If the child has some disagreement with the accounting that we provide them, obviously we try to deal with it and answer whatever questions and so on. But if the minor is still not prepared to sign a release, then our office can go to court to have our accounts reviewed and hopefully approved by a court, and then as well that would provide a release to us. So then if the court says that our administration of the funds has been okay, then we would take our fee and pay out the balance to the trust beneficiary. As I said, so the other source of funds would be a damage award. Essentially, funds payable to a minor resulting from injury or loss to that minor child. The most typical situation would be a minor child involved in some kind of auto accident or personal injury situation. Potentially, it could be a medical malpractice situation. Unfortunately, we have a number of trust funds that we hold on behalf of infants because there were problems in the birthing process, or we might receive funds because of the wrongful death of one or both parents of the minor, right, in those kind of situations. In regards to personal injury, I always relate this story because when I read the situation, you always think kind of a motor vehicle accident and something of that nature, but we did have one man who was injured quite severely on an escalator. And so I always warn my kids, you think, oh, you're playing around on escalators and whatever. No, you always got to be careful in all circumstances. So usually in terms of damage awards, how we find out is that in most cases, the parents are around and so on, so the parents will commence some kind of legal action, and one of the plaintiffs in that legal action would be a minor child or minor children. Normally then a lawyer would know that if there's minors involved, they need to contact our office and see again what kind of involvement our office is going to have in that legal process. One of the main reasons why the public trustee is involved and how the legislation sets up is that if a minor is injured in a motor vehicle accident or any kind of personal injury accident, then the only way for the at-fault party to be released from responsibility or further responsibility after paying a settlement or a damage award or whatever is for a court order to be issued, again, approving of the settlement and releasing the at-fault party from any further responsibility. Now, if you have a minor situation where maybe it's a very minor motor vehicle accident where, the minor's going to get $1,000 or $500 or, they got a bump on their head or they were just shook up and they didn't want to get into the car for a week, then some insurance companies will kind of take the risk to say, okay, we don't need to go through the whole court process. We'll just get releases signed by everyone and that'll be sufficient. But technically, under our legislation, the minor could have a right when they turned 18 years of age to again sue the insurance company and the at-fault party, right? So particularly when the injuries are more severe, the insurance parties on behalf of the at-fault parties normally will want to get that court order, and in order to get that court order, it does involve the public trustee. The public trustee, again, as part of the process, we will normally be provided with all medical documents and so on to confirm that if some kind of settlement is reached with the parents and the insurer for the at-fault party, that settlement is an appropriate thing. Because what our role is that we are asked to recommend or not recommend that settlement to the court. And again, so that's why we have all the medical reports, and our legal department will kind of do our own review to determine if that settlement is adequate or not. And then we will provide our recommendation to the court. Because as I said, only the court can release the minor's interest in that particular circumstance. After the settlement or after a trial or whatever happens, any funds payable to the minor might be paid to the public trustee's office, or again, if the court order appointed a trustee for those funds, could be payable to the trustee, or again, under the legislation, if the amount is small enough under that $10,000 threshold, potentially the insurance company could pay the funds out to the guardian of the minor. If the public trustee's office does receive funds on behalf of a minor, then they're invested, as I previously indicated, in kind of an individual bank account on behalf of the minor, which we pay interest on. Again, just like monies that we received from an inheritance, if they're under that prescribed amount of $10,000, we can, again, in the appropriate circumstances, pay the funds out to the guardian who has care and control of the minor. if we are holding funds for a minor and a request is made to pay out some of those funds on behalf of the minor while the minor is still under 18, then again, it is possible, but the reasons why we will pay monies out of a personal injury settlement are a little bit more restrictive, because in that case we are paid the monies for a more specific reason, either to pay for the pain and suffering of the minor child, or very specifically to compensate for a scar or potentially future medical procedure or medical devices that an individual might need. So we are a little more stringent in what we might pay out funds for while the minor is under 18. Plus, as well, in most cases, there are parents involved, and the parents still have a responsibility to provide and maintain for their own children. So again, it's all dealt with on a case-by-case basis, but there are a few more restrictions in regards to what we will pay funds out for. And if we are paying funds out of a minor's personal injury settlement, then if possible, we will try to make the minor aware that funds are being paid out when they turn 15 years of age. Again, subject to conversations with the parents if different circumstances arise. And again, particularly for personal injury money or funds received from a damage award, very seldomly would the funds be payable at an age other than 18. So when the child does turn 18, then again, subject to any concerns that we might have or we might be aware of about the competency of the minor child. So again, in some of those larger personal injury awards where we know that there were brain injuries or something of that nature, sometimes it may be clear to us that the minor individual who's turning 18 is not capable of managing those funds themselves. Sometimes we might not know, so we might ask for some medical information to confirm either yes or no if the minor is capable of managing the funds that we're going to provide to them. If they are capable, then we follow the same process. We provide them with an accounting. If they're satisfied with the accounting, they would sign a release and we would pay them the funds. If the information we receive indicates that the beneficiary is not capable of managing their own financial affairs, then we will require that a trustee be appointed for them as an adult, either a private individual or potentially the Public Trustee's Office. Under the Minors Property Act, so if the Public Trustee is holding funds on behalf of a minor and it's over the regulated amount, so either we couldn't pay it out to a guardian or we felt it wasn't appropriate, then a guardian or, to be honest, any interested party can apply to the court to be appointed as trustee of the minor's estate, either generally or specifically as trustee of a specific property, such as the funds held by the public trustee on behalf of the minor. Under that piece of legislation, if an adult, so usually it would be a parent, applies for trusteeship of their minor child's estate, then the legislation provides that adult, that parent, would actually have to provide a bond unless the court dispenses with the bond. Essentially, a bond is like an insurance policy that the proposed trustee would have to obtain that kind of guarantees that if in fact they abscond or did something inappropriate with the funds that they're holding for the minor, then the bond could be called upon to make up the loss to the minor. So again, if the person was applying to be trustee of the minor's estate and it was $50,000, then the bond would be at least of that amount. So again, if in fact the trustee inappropriately managed those funds and there was a loss to the minor, that the bond would be able to make up any loss to the minor. Even if a person is appointed as trustee for a minor's estate, whether it be generally or specifically, the trustee is still bound by the provisions of the Trustees Act in regards to what they can invest in, unless the court gives them other investment power. So there are situations where a parent might say, well, I want to have control because I'm an investment advisor and I know that I can get way better than the 2.5% that the public trustee is paying. I can invest it in this, that, and the other thing. Well, even if they become trustee, if this, that, and the other thing are not approved trustee investments under the Trusteeship Act or under the Trustee Act, then the trustee would have to have gotten specific authority to invest in those investments from the court when they were appointed as trustee. Otherwise, they still wouldn't have the authority to make those kinds of investments. And that is the end of my presentation, so I'm open to any questions.
Yeah, so we have a few questions that have come in. This first one is a situation. This person says, I have a 19-year-old client who is involved with child welfare and has inheritance coming in. However, the client has identified that the income money might be spent on drugs. The client has asked for help in managing the inheritance. Would it be possible to get public trustee involvement with this client if they have no healthy and reliable family members?
Well, for someone who's 19, so it actually wouldn't fall under the official guardian aspect of our office. That would fall under the kind of represented adult and the guardianship and trusteeship aspect. So what our office would have to determine is if the person A is competent or not competent in regards to managing their own financial affairs. So unfortunately, the person could be competent and still make the decision to use their funds for drugs. And if you're a competent individual, unfortunately, or fortunately, however you want to look at it, you can make decisions about how you handle your funds, even if other people don't agree with them. So really the key there would be first, is the person competent or not competent to manage their own financial affairs? If they're not competent, then potentially the public trustee might get involved. And there are other criteria that the public trustee uses to determine if it's appropriate for the public trustee to get involved or not. There are other kind of informal avenues that might also be pursued for this individual. What I would normally suggest is for the person who's dealing with the individual, the 19-year-old individual, to contact our office for more information to discuss, again, if it's appropriate for the public trustee to be involved. But that would, since the person's 19, they wouldn't actually fall under the official guardian aspects of our office anymore.
Our next question is, can the public trustee apply for settlement from a class action suit on behalf of a minor in the case where there are no family members able to?
To be honest, I'm not 100% sure. I believe the public trustee would be able to, because in general, for a minor who's a resident in Alberta, the public trustee is the trustee of the estates of all minors in Alberta. So in that case, so if an individual, this individual is aware that that situation is arising where that minor might be a plaintiff or should be the recipient of in a class action lawsuit, and there is no adult individual who's able to kind of pursue that claim on behalf of the minor, then I would suggest contacting the public trustee's office to see if the public trustee should get involved.
Our next question is, if I put my grandson's name on a lottery ticket and his ticket wins, would the money go to the public trustee's office?
The short answer, if your grandchild is under the age of 18, then yes, the money would go to the public trustee's office to hold until the individual turns 18 years of age. That's really the reason why, as soon as I started working for the public trustee's office, I kept telling my mother not to put my kids' names on their lottery tickets. I understand they were paying a great rate of interest, but I don't really think that was her intention.
Regarding trusteeship for minors, where the parent or guardian is granted trusteeship, does the court usually set a review date to review the accounting spending of the trust, or how much oversight there is?
In that circumstance, it is up to the court to determine if there's going to be any kind of oversight or not. So again, I don't know kind of anecdotally what the court usually does or doesn't do. I would guess that it would depend on the amount of funds that are available, the age of the minor. Again, you would potentially, if the minor is older, closer to the age of 18, then the court might indicate that they're even to, the minors to be involved and aware that whoever is named as trustee is holding these funds, so they can kind of monitor it themselves. Or potentially, again, if the minor is younger, they might appoint the public trustee, or not appoint the public trustee, but direct that the trustees to provide an accounting to the public trustee's office on a periodic basis. But I don't think there's any hard and fast rules. Certainly the legislation doesn't provide for any kind of mandatory accounting or anything of that nature on behalf of an individual who becomes trustee for a minor's estate.
The next question is, how long do we at the public trustee hold the funds after the release has been sent out?
Generally speaking, well, I guess if that means if we send a release out to an individual and we never get it back, right? So either the person forgets, they never return or whatever. So essentially the public trustee will hold those funds at some point on behalf of the government, but forever, right? So if someone turned 18 years of age and they had moved around, so we sent out a release to them and it came back that the person had moved, and so we had no other way, and we do search, and we do have different ways of searching for individuals. So we look for that individual and we are not able to locate them, then again, there is a process still within our office to hold those funds for a certain period of time. Then it's at a certain period of time, there's another process that involves us clearing that account from our books, but it still remains an account on the government's books, so that again, at any time, if that individual comes forward and can identify themselves and prove that they're that individual who we were holding funds for, we can retrieve those funds and pay it out to them with a certain amount of interest.
If the public trustee is holding funds on behalf of a minor, at what age is the minor told about the existence of the trust funds?
As I had indicated, if monies are being paid out of the funds, then we do try to make the minor aware that those funds are being paid out at approximately age 15, unless there are special circumstances that would indicate that that might be harmful in some way to the minor. If monies aren't being paid out of the fund, so again, we get a personal injury settlement for a 5-year-old child, the parents never request monies for that child, so we just continue to hold it and earn interest. Periodically, we will confirm the address of that minor with the parents, so we have the current address. So then shortly before that minor turns 18 years of age, we would be sending out release and accounting documents. So potentially, the first time an individual finds out that they have a trust fund with our office might be when they get a release and an accounting in the mail, right? Because if we're not paying out funds, at this point we don't have a mechanism to notify every individual at age 13, 14, 15 or whatever that we're holding funds on their behalf. It's kind of, for most of those situations, it's up to the parents to advise their children that funds are being held in trust for them. Here you go, Melanie.
Thank you, Lincoln. I just want to remind you that today's webcast is part of the larger joint initiative by the Government of Alberta and the Human Services Learning Series. For more information about this series, check your emails for our regular updates or go to hslearningseries.ca. You can also follow us on Twitter at Alberta Human Services and with the hashtag OPGT. Again, thank you for attending today's presentation, and please continue to look for updates on sessions from Employment First, the FASD initiative, and the Alberta Brain Injury Initiative. Thank you.